Hello, and welcome to this edition of Nelson Mullins Education Law webinar series. We're glad you could join us this afternoon. My name is Dan Cohen, and I'm a partner on Nelson Mullins Education Law team. Nelson Mullins is an AmLaw 100 firm with about 800 attorneys and policy advisors across 25 offices in 11 states plus Washington, D.C. Among other practices, we have a dedicated team of attorneys focused on serving all legal needs of educational institutions, including in the areas of labor and employment, healthcare, and issues affecting academic medical programs, construction and real estate, intellectual property, privacy and information security, and unique issues affecting education institutions like student and faculty discipline, sexual misconduct, and athletics. Each month, we will host a free webinar addressing legal topics across these areas and sometimes more frequently as issues arise. Yesterday, we hosted a webinar related to responding to this coronavirus crisis that's closing down schools across the country. If you have questions about that webinar, please contact any one of us, and we'd be happy to share information with you. And of course, please feel free to contact any one of our education lawyers if you have any questions about our webinars or any other legal issues affecting your institution. Today, Samantha Lewis and Suzann Wilcox are going to focus on due process and student discipline. Despite the crisis that we're in, Title IX proceedings and other student discipline proceedings don't necessarily stop. So today, Suzann and Samantha are going to focus on the possibility and the probability of continuing in the litigious climate that we have, and how not giving appropriate due process can lead to complaints and costly lawsuits. So they're going to outline recent case law on students' rights, discuss best practices for providing due process protections during student discipline tribunals, explain similarities and differences between K-12 schools and higher education institutions, and give practical tips and tricks to avoid common and sometimes costly mistakes. Suzann Wilcox has been providing legal services to a variety of educational entities for the past 2 decades. Suzann focuses on policy and process development, legal training for staff at all levels, board and superintendent advisement, day-to-day issues impacting schools and students, and technology and privacy concerns. As one of the partners on our team, Suzann works to get clients to a place of yes in a legally compliant fashion. Samantha has spent her legal career as a litigator and brings this perspective to all of her client matters, both in and out of court. After serving as a felony prosecutor, she started representing education institutions 7 years ago. Samantha focuses her practice on student issues, assisting her education clients with student discipline process, handbook development, training, special education matters, and litigation of discipline and special education claims. Samantha works closely with her clients and views her role primarily as proactive, advising and helping clients to avoid issues before they occur. And with that, I will turn it over to Samantha and Suzann.
Good morning. This is Suzann Wilcox. I'll be starting us off today. I just want to say welcome. I know your time is valuable, and I also know that you must be living in the new world that we are living in. So I just want to take a second to say thank you. Thank you for the hard work you're doing for students, for your staff. I want to say thank you for everything you're doing, around the clock right now. And for our presenters, if you could make sure you are on mute at this time, that will help me not get distracted by shiny objects that I hear floating through the air. I would appreciate it. I'm going to just start us out with a quick overview of kind of what we're going to be talking about today. While this webinar was not really intended to be a COVID-19 webinar, we will be touching on that as we go through today. So I just want to let you know you will hear some of that. That is going to change day by day. As my grandpa would say, pigs could be talking tomorrow. So we don't know what tomorrow's going to hold, but we'll give you our perspective from today, and we'll keep you posted. So please feel free to email us if you have specific questions. There's a chat feature in GoToWebinar that you can utilize. We're not going to be answering live questions today, but if you'd like to leave us a message, we'll be happy to either get back with you or we'll definitely get back with you, but potentially take that into account for another webinar on another day. And of course, we provide these free of charge, and we're happy to be of service to you and your school entity. I apologize, I'm having just a little bit of a little bit of a delay there in my changing of slides. We just want to remind you all that, number one, so for some of you, we may be your lawyers, but for others of you, we are not your lawyers, so we can't really give you legal advice. We do recommend that you reach out to your lawyers if you have any specific questions. If you don't have lawyers that you work with on these issues, we'd be happy to assist you. feel free to reach out to us. And we also want to remind you, we know people are signing in from various states across the nation, and we want to remind you that state and federal law can differ. Even the interpretation of federal law, which should apply across all 50 states, can differ state by state. And of course, your district policies or your school policies or your university policies may impact how we would advise you in that situation. So this is really just covering best practices, practitioner tips, and things to think about and get those juices flowing for you, especially in this environment. Sometimes it's really helpful to go back to basics and remember sort of what we're here for and what due process really looks like. Well, we know if you took an education law class, you probably remember that the roots of due process exist within the United States Constitution. And essentially, the Constitution provides that state cannot take away a property right without giving the person some sort of due process of law. What process is due is kind of the question that we'll be talking about today. But we know that we can't just without any fanfare, any process at all, just take away property rights of citizens. And because it's a constitutional right, we know that these are among the most sacred rights granted to the public, and the courts respond thusly. They view these as sacrosanct rights of our public, and therefore the penalties for violating these rights can be extreme. The lawsuits alleging a violation of due process can be long and hard-fought and very expensive. And we also want to remind you, if you rely on sovereign immunity or official immunity in your state or your jurisdiction, sovereign and official immunity will not protect you in these type of situations. So when someone alleges a violation of constitutional rights, generally you're not going to have any immunity protections to help you with those. So it's very important that we take these seriously and that you feel like your processes are in good shape. Of course, if you remember from your constitutional class or your education law class or just even maybe government when you were in high school, we know that the state actor is who we're really interested in as far as who provides due process and then who can get in trouble for not providing due process. So remember that if you are a state actor, that really applies to you. If you get government funding, public schools, public colleges and universities, that's all going to fall down to you. Now, let me speak to my private colleges, my private grade schools right now. You are not technically subject to the same regulations. No one can file a due process claim against you. So those scary lawsuits I was talking about, that's not really your territory unless you're taking public funding. You really do need to know whether you fall under these requirements, however. So that's something to make sure you understand, because you could be a private school technically and still get public funding, and you're still subject to a lot of these rules. But assuming you know that you're not, you can kind of take a deep breath on that lawsuit part as far as constitutional violations. However, I want to remind our private school friends right now, our private university friends right now, that your obligations to students really exist in contract world. And so that means that your students or your parents could allege a breach of contract where you violate your own policy or your own contracts that you have with students and staff. And remember, if these get litigated, judges are like myself, Samantha, and Mr. Cohen that was speaking earlier. We think in terms of due process, even though it may not technically apply to you. So a judge may still apply those things consciously or subconsciously as an equity or fairness matter. And so one of the things you can do to sort of protect yourself is to meet this higher standard of due process, and in some ways maybe a modified version of it, and follow the same due process guidelines for public institutions. So even if you don't fall into that public zone, just remember this can still be helpful for you. And make sure that you, as a private institution, have a good policy guideline. You've trained your staff. All of those things are in place so that those breach of contract issues won't be an issue for you. So that's just a practitioner point for our private school friends. So again, going back to your roots in your education law class, and I'm sorry if you didn't enjoy that class because I certainly have been referencing it quite a bit as we've been talking here. The Due Process Clause of the 14th Amendment of the United States Constitution requires that there be some sort of hearing before you can remove government benefits from a person. So in interpreting these rights, the United States Supreme Court, who we lovingly call the Supremes, determined that an important part of due process is some sort of hearing. Goldberg did not talk about education. That really wasn't on their radar at the time, and it was still kind of an open question whether you could take away a student's education opportunity pursuant to these due process rights, and the states were all over the place. Enter our good friend Goss v. Lopez, and this is a case that's been on the books since the 1970s. Samantha and I have had trainings where people look at us like we've grown another head because they could never heard of such a thing as student due process before removal, which is a little scary when you're standing in front of administrators that have been, around for 50 years or so. But we persevere. So essentially what the Supreme said in this case is there's really no federal right to an education, right? We don't have a federal education system in this country, but most states, I think, in fact, all states, now do provide public education. And therefore, because you provide it, you can't just take it away from students without some sort of process. But what Goss said is, look, we're really mostly talking about minimum process as a floor, right, for any length of removal for a student. So again, you might be in familiar territory with this analysis, but we learned some important things in this case, and we learned that we needed to at least have some sort of floor, making sure the removal was not mistaken or arbitrary. So that was something that Goss taught us. There is some sort of right, and it starts with a bare bones minimum due process. And moving on to our next kind of little point about Goss, what this looks like is that before removing a student from a state-provided educational environment for any length of time, the student must receive a minimum of due process. And this will include notice of the charges against the student and an opportunity to tell their side of the story. It may include sharing evidence of why you think they did it and following any leads they provide to you as far as, well, I couldn't have done it because I was with Johnny or I was with Susie. And then you need to go follow up and find out, were they really with you? Is this a case of mistaken identity? Of course, in today's age of video, some of that is a little bit obsolete, but not all video runs in all places. So sometimes you are tracking down live witnesses. And all of this basic conversation has got to occur before you discipline them. So what I always tell folks is, saying you're suspended, what do you have to say for yourself, what's your side of the story, is not going to be sufficient. This happens before notification of suspension. This happens before you make that determination of suspension. And I like to tell the story of an old person that I knew, an old client that I knew years and years ago of a friend of mine, and he would actually ride around in a golf cart on the school campus and yell out of the golf cart, "You're suspended. Go home." That's not due process, right? In case you had any doubt in your mind, that's not due process. We've got to really ask them their side of the story and talk to them about it. And really, let's face it, this is really best practice anyway, whether you're in a private or a public setting. Having a conversation with a student about what they've done and why they did it and what's going on is just basic educational process. So this should not rock your boat really in any way. And remember, this is only an opportunity. If they refuse, you can move on, but you have to give them a real opportunity. We'll talk a little bit more about that in a minute. All right, so long suspensions or permanent expulsions require more formal procedures. However, that's what Goss said. Well, okay, that's for your short term, your 10 days or less. You got to just give them that minimum. But for longer removals, the Supreme Court has said, you need more than that. Well, okay, Supreme Court, what does that look like? And the Supreme Court said, nay, we're going to send that back to the states. We're going to let the states decide what due process is due for a longer removal from a state-provided education. Typically, what this is going to look like depends on your state, but you're usually looking at some sort of formalized disciplinary hearing, an opportunity for the student to present evidence and have witnesses, and some kind of neutral fact finder. Spoiler alert, it should not be the principal of the school where the child goes. That's not a neutral fact finder. At least that's my opinion. Your state law may disagree with me, but generally I would say you're going to have to get somebody from outside the school setting. And a standard of proof will be provided generally by the law. In our jurisdiction in Georgia, it is preponderance of the evidence. That's basically 50.1%, or as they say, 50% and a feather. So more likely than not is the standard. It's different than the criminal justice standard of 99.9% or beyond a reasonable doubt. You may also have requirements in your state for an attorney to be there. Again, you want to look at your state's requirement. And so that's something you need to make sure you have a good handle on. Of course, we thank the Supremes for recognizing that formal due process for a very short-term removal from a student from an educational environment would completely overwhelm schools and universities and would be completely unworkable. So we appreciate them saying, look, really just the minimum due process is what's required. How that is required. However, I want to remind you this exception at the bottom here. Some states do require hearings for specific rule violations regardless of the amount of discipline that is being sought by the institution. For instance, for K-12 institutions in Georgia, if you commit an act of physical violence against a school employee, there is an automatic hearing involved in that. And you may also have a university or school policy that requires a hearing in certain matters no matter what the removal is. And I want to just remind us as a practitioner point with that, we don't want to have more hearings than is really needed. So let's just make sure that we're not creating lots and lots of legal opportunities for appeals and things like that when they're not really needed. If you are having thousands and thousands or hundreds and hundreds and hundreds of hearings, I would say you need to look at your processes. And one of the first ways we triage a client when we start working with them is we look at how many hearings they're having. If they have a high number of hearings compared to comparable districts across the country or state, I can almost guarantee there's something going wrong with their discipline process. So be cognizant of how many hearings you're having. Procedural versus substantial due process. I just want to, substantive due process and procedural due process are different. Substantive due process is talking about, are we narrowly tailoring this process of removal to serve a legitimate educational purpose? There is a substantive due process right to an education, and then the procedural is what processes do. So there is a difference between substantive and procedural due process. I'm not going to spend a lot of time on that. Frankly, we spent about a whole semester in law school talking about that. But I just want you to know there's a separation there, and it helps you sometimes think about how to tease these out. All right, so let's face it. This is why you really logged in, right? Maybe hoping we would talk about some of the COVID-19 information. Well, I won't disappoint you, and let's go ahead and not be naive. Even if you are closed right now, students may still require disciplinary action when they are closed. Let me give you an example. We all know that the cyber world is just ripe for opportunities for students to get themselves in trouble. You may have an athletic code of conduct, which of course a lot of our athletic events are suspended, but you may have an athletic code of conduct that you're working with right now that requires that students don't do X, Y, or Z when they're out in public, and you are seeing pictures that that's still happening. You also, with our institutions being empty and buildings being closed, we might see an uptick in theft, things like that. So I can't say that just because schools are closed, you're not going to have any discipline. You may not have a lot, but you might still have some. And if you're open and operating normally, of course, you're proceeding as you normally would, but you might have an eye towards what you're going to do if you close. This is an unprecedented time, and you all know that. I shouldn't have to tell you that. Essentially, when we're dealing with discipline, you could wait to deal with the discipline until you reopen. However, what a lot of you may want to do while you're closed, if something comes up, you may want to go ahead and get it in play before school reopens so that when the student returns, the discipline starts on day one. So just a reminder with due process, you don't have to do due process in person. You can call, you can ask for written or emailed statements. That's considered, an opportunity to tell their side of the story. And again, we're just giving them an opportunity. A lot of times we'll call the parents and say, hey, we want to get your child's side of the story. And if they're a minor, the parent may say, nope, I'm not going to do it. Nope, can't talk to my child. Well, we just document that we've tried, and we move on with our action the way we've determined. Sometimes we might send a letter to parents, especially right now when you have a little more time, potentially if you're closed. You might send a letter and say, we've been trying to get a hold of you. We'd like to get their side of the story. Here's a statement form included. Please return it to this attention and give where you want it sent or whatever email. You may send a picture in of the statement, whatever you want to do to make it easy for them. But due process can still happen, and we still can investigate to a certain extent too. Now, you need to check with your talent or your HR folks to understand what amount of work you're getting out of your employees, and hopefully they're working remotely and they can manage something like this. But don't think that just because the schools are closed that you can't necessarily begin. And I will say, at least in the state that we're in, I think that the prevailing thought is right now we're not treating these days of closure as a school day necessarily. So if you are still giving, I'm just switch slides while I'm talking about this, but if you're still giving these students educational access, then I would say that you have a good argument that these are not school days. And so really the suspension doesn't start until they come back. So that's just something to think about. Right now you might have some hearings that are postponed. So let's say your school or your university is closed because you cannot have hearings. Well, this is a good time to make sure you're clearly communicating with your folks. Not only as far as what your behavioral expectations are, if you still have behavioral expectations for your students while they are out of school, you're going to want to communicate those to parents and parents and students, but also make sure you're clearly communicating any postponement to the parties. Be mindful of time requirements to hold the hearings. And again, our interpretation right now, these are not school days. Make sure you're talking to your legal counsel about your jurisdiction or your obligations under whatever law this hearing is being held under, because again, we can have hearings for a variety of reasons, and be prepared to plan to reschedule hearings upon opening. So what you may want to do is create a chart and then consider the priority of hearings. How many days have they been out? When does their timeline run? And maybe the severity of the matter, because some students may have to come back before you can hold their hearing, so we might let them come back before their hearing occurs so we don't run afoul of timelines. But if it's a very severe or dangerous student, you may not want to do that. So let's start thinking about a process to get those hearings ready when you come back. And just a reminder, a lot of us are doing continuing educational opportunities if your state allows for it. But let's think about students who were on suspensions. I'm going to go to the second bullet here. Students serving short-term suspensions, which is 10 days or less potentially, or maybe just a shorter term out if you're in a private school. Consider whether to continue that suspension after school opens. So essentially suspending the suspension. We think the cleanest thing that you may want to consider is allow these students who are on these short-term suspensions to potentially participate in a distance learning opportunity, because it's going to get tricky to argue that they're not school days if you're giving other students educational opportunity and you're not giving these students educational opportunities. The cleanest thing maybe to do, okay, if you're on day 5 and I gave you 10 days, that we'll stop it here. You can do the teleschool or the virtual school, and then when we get back, you'll start on day 6, and then we'll run it through the last day. So when we get back to school, and letting folks know that that's how we're going to do it. But of course, you want to be careful of contacts with victims, whether those are staff or students, and make sure that we lay out the expectations for how that's going to work if they need to be in any kind of contact with staff or other students. And again, it's generally preferred, at least in Georgia and probably other states around the nation, that we allow students to continue to receive education during a time of discipline rather than completely excluding them from that opportunity. So since they won't be in the educational environment, that definitely limits the contact and chance for ongoing issues. Doesn't eliminate, but it limits it. And again, we want you to be thinking about how to deal with contact with victims or students who are being disciplined for technology violations. I would say you want to be careful to be consistent and to make sure that you are not treating different groups differently. So try to be as consistent as possible, because you don't want people alleging discrimination. But if you have a legitimate, non-discriminatory reason for why you need to treat certain classes of students different, that might be something to consider. And again, talk to your attorneys about how to handle this. And just going back to the last slide, I'm sorry I skipped over this. If you've got a pending hearing, again, what we would say is go ahead and maybe stop the discipline from running, and then let them participate in teleschool, and then start the clock back when school gets back, and make it very clear when their hearing's going to be, and make it be within those timelines required when you return, if that makes sense. So hopefully that gives you kind of an overview of what to do with our students in this time. Again, we are definitely in a weird time. No one has a perfect answer for this. Keep in touch with your US DOE guidance, your local DOE guidance, and make sure you're following your policies as best you can. If you need to change your policies in light of this unprecedented time, make sure that you give notice to families about that and what the process is going to be. Communication, communication, communication. That stems a lot of issues that can happen. And of course, let's start thinking now, and I've already referenced it a couple of times, of how you're going to reopen. Hopefully you don't have a ton of new incidences waiting. You'll have a little time to catch up on hearings, kind of like when we start the new school year. Sometimes we start with a clean slate. And again, that doesn't mean there won't be any disciplinary instances. I think the ones that we are kind of thinking that we're going to see is our off-campus misconduct. If you have an off-campus misconduct rule, if you have an off-campus felony behavior rule like we do in Georgia, or technology offenses, they love those technology offenses. And of course, as I mentioned earlier, your athletic or extracurricular code violations, where you have expectations for students not to do X, Y, or Z, even on their off time, and how are you going to implement those? And make sure you're giving notice, again, to students. Don't forget, our behavior code, our athletic code of conduct, whatever, is still applying during this time, and we expect you to exhibit good judgment, and you can still be disciplined if you do something boneheaded while you're out. And maybe that will help stem some of this, idle hands are the devil's workshop, right? That's what they say. So with that, I just want to remind you one more time that we do have the chat function if you'd like to leave us questions. I'm going to turn it over to Samantha for her to do her part. But if you, for some reason, don't want to use the chat feature, you can always email me or Samantha. We're happy to interact with you personally if you would prefer not to use the chat function. And with that, I'm going to have Samantha Lewis, one of my wonderful team members here, to take it away.
Hi guys, this is Samantha. So here we're going to cover some information about some more best practices with due process. What we're going to talk about here are your code of conduct, your school rules, your student handbook, however you name that, call that. Notice, how you provide notice to students of their suspension or their disciplinary incident, and the hearing, discovery issues for a hearing, as well as those hearings or tribunals at your school or university, and some issues for private schools to consider in the due process best practices. Okay. So first of all, our code of conduct or student handbook, this is really your first line of defense, is creating a written list of rules that address the student behavior, address what is not acceptable at your school or university, as well as the potential consequences that students are going to face for violating one of those rules. If you do not have a student handbook or a code of conduct, I cannot stress enough that this is really something you should consider developing. People want to see in writing what they can and can't do, and they want to see in writing what the consequences are for doing one of those actions that they're not supposed to do. And you might think that things are obvious, but I cannot tell you how many times I have been in a hearing or talking to a student or their attorney who tries to tell me very straight-faced that the student just didn't know that they weren't supposed to fight in school, or didn't know that they weren't supposed to batter a member of staff. So you cannot assume that people are going to use common sense or good judgment and act accordingly in on your campus. You really need to put this in writing. Keep in mind when you're writing a handbook, and especially considering the consequences, the student's age that you're addressing. For you K-12 institutions, it might be a good idea to consider different ranges of amount of discipline depending on whether that student is an elementary student versus middle or high school. In some states, I know you may not have alternative education opportunities available for younger students. So that is something you really need to consider if you are considering suspending or expelling those really young students for certain amounts of time, because they may not have those alternative education opportunities available that you may have for your middle or high school students or university students. When you are also writing your handbook, what you're also going to want to potentially look at is your state criminal statutes when you're creating rules, especially if you're starting from scratch here with a new rule, or you are updating your code and you really don't know how to word a rule violation. a good starting point is to go to your state's criminal laws. So if you are considering writing a rule for theft, take a look at what your state criminal statutes say about theft. This is a good idea for a number of reasons. Number one, that state criminal statute has been written by the state legislature. So we should be able to assume that they're probably okay with the language that's in it. Many of these states' criminal statutes have already been put before court and judicial bodies and been held up to judicial scrutiny as well. So as much as you can mirror that state criminal statute, you're going to save yourselves potentially a lot of headaches versus if you try to write rules on your own, because you don't want to have unclear language in them or things that the judicial system is not going to support. Keep in mind, do not use the criminal statute, though, as a be-all and end-all here. Obviously, there's going to be rules that you are probably going to want to include that there are not state criminal statutes for. For example, cheating. Obviously, I think any school, university, college is going to want to have a rule that addresses students cheating. That's not necessarily a criminal violation out in the real world. Whether it should be or shouldn't be is another debate. But so, for example, something like cheating is something you're going to want to have in your code of conduct, and you may need to develop that language without the benefit of the criminal statute. Also, of course, we cannot mirror the criminal statutes when it comes to the amount of discipline we're seeking. We cannot incarcerate students, and we don't have the full range. So be mindful of that as well. When you are writing your codes of conduct, you also want to consider your state rules, regulations, and laws. Some states, they do address specific rules that must be included in your code of conduct. For example, here in Georgia, there are requirements that rules about battering teachers be included, that battery of other students be included. There are actually quite a few rules that our statute here in this state lays out that specifically must be included in student code of conduct. So certainly if your state law requires that a rule be included, you want to make sure that that is included. Also keep in mind your state rules and regulations regarding minimum or maximum consequences for certain rule violations. Some states are going to include laws that say if a student does X, Y, Z, the minimum consequence is going to be this. So you want to keep that in mind when you are developing the range of consequences and developing a handbook, because if there is a state law on point as to the amount of discipline that must occur, you are going to want to make sure that you are including that you're notifying students of that, and that you implement that when a student violates one of those rules.
And I'll just chime in here as well. These slides are quite beefy, so because of our time constraints today, we won't be able to hit every single point, but we drafted them in such a way that you could kind of go back and review and kind of remind yourself of some of these things. So we know that you all are high-level folks and you understand, some of these basics, but just so you know, we may not hit every point on these slides, but this information is there for you, which we put quite a bit on here just to make it kind of a nice desk drawer supplement that you could grab whenever you had a question about it. And I'm going to try to change the slide here. There we go.
Okay. Your student handbook, you should address jurisdiction issues. Jurisdiction is basically where an event happens and whether or not you can discipline for that based on where that discipline incident occurs. So generally, you are always going to have authority, unless your state law says otherwise, to discipline for any incident that occurs on your campus. So any buildings, grounds, dormitories, public spaces, if there's student organization spaces or building that are on your campus and things occur there, you are likely free to discipline for those incidents. Same with school events and school-provided transportation. Your state laws may give you broader range of discretion or narrow some discretion in some of these jurisdictional issues, so you're going to want to review your state law in determining where you have jurisdiction to discipline. You also need to consider behavior off campus. Don't think that just because something did not happen on your campus or at one of your events that you are in the free not to address it. Sometimes off-campus behavior is required to be disciplined. So again, you're going to want to look at your state laws to determine what it says about off-campus behavior, if there's any off-campus behavior that is required to be disciplined. For example, here in the state of Georgia, for students that commit felonies off-campus, not during school hours, that can affect the school environment, schools are required to discipline for those incidents. So that's something to consider. You also need to consider what is off-campus, which can be kind of a tricky thing sometimes to consider because there are a lot of gray areas. For example, in our K-12 environment, school bus stops can be a school area, but that's a very, very much a gray area for a lot of people to determine where the school bus stop ends and where it begins. You also need to consider some rule violations and whether or not they need to be reported to law enforcement. In a lot of states, there's going to be requirements specifically for students in a certain age ranges that you report incidents to law enforcement. And certainly if you feel that a criminal violation has occurred on your campus, it's probably a good idea to notify law enforcement so that they can be involved in any criminal investigation that needs to occur as well. Do not feel that you need to open up a criminal investigation. You all are not law enforcement officers. You are not trained to conduct criminal investigations. So you should really leave that up to the authorities. And I think we can go on to the next slide, Suzann, unless you have anything to add here.
No, the only thing I would add is, we've done a training in the past called, the 10 fastest ways to lose your job. And one of the fastest ways to lose your job is not making a mandatory report that's required by law and keeping things internal rather than turning it over to the authorities. So that's a great point that Samantha made there.
Okay, in that code of conduct, as well as rules and what consequences you can face for breaking those rules, it's a good idea to list some of your procedures, those due process protections that you're providing students. I can't tell you how many times I have a conversation with a family, with a student, or somebody who wants to see something in writing. And the more you have in writing that you can show somebody, this is our procedure, this is our policy, this is why we aren't going to do what you are asking us to do because it's in violation of our policy, the better off you are. People like to see things in writing. So it's a great practice to include in your code of conduct some of those due process protections, guidelines for when hearings are granted. You're going to have a lot of people that want a hearing, even if they've been suspended for one day. Obviously, the Supreme Court, as Suzann touched on earlier, says that we don't have to do that, but it's good to put that in writing for people. You want to outline all of your hearing procedures. If there's a timeline for hearings, there may be a timeline in your state or your jurisdiction as far as how quickly you need to hold hearings. So certainly you want to provide information about that. You should provide some information about who can attend hearings. The accused student should probably always be allowed to attend their hearing. If they are underage, parent or guardian should likely be permitted to attend. You need to consider whether any legal representation and whether you want them to notify you of legal representation. And as far as who else can attend, for our clients, we generally try to keep as few people in the room as possible. We don't like these hearings to turn into three-ring circuses with every relative and family member coming along. But that's really up to you, and your hearing officers and your policies and procedures can really help to limit your hearings from turning into circuses with 20 people in the room. You want to address any procedures you have for witnesses. You may want to have a subpoena procedure for witnesses or a way for families to request subpoenas for witnesses. If you have that, you should include that. You should also include any information about evidence, and we will talk a little bit more about evidence in some discovery slides coming up. Finally, you should also include your appeal process in your code of conduct. That should be clearly outlined as to how somebody appeals a hearing decision, any timelines for appeal, and real specifics about how they do it. Does it need to be in writing? Is there anything that you're requiring to be included for it to be a valid appeal? Who does it need to be sent to? What are the timelines? What are the deadlines? Those are all things to consider with the appeal process, because if you don't notify somebody fully of their appeal process, that is something that courts typically are going to hold that you did not provide them the correct process to appeal. And a lot of courts will accept appeals that maybe are incorrect or untimely, even if you have not spelled out your process very clearly to your students. Okay, some best practices for our K-12 schools when it comes to your codes of conduct. You want to make those codes of conduct available to not just your students, but also their parents and guardians. Most of your students are obviously going to be underage, so their parents or guardians are the boss. They are the ones in charge, so they really need to be the ones who are notified of what is included in that code of conduct and what happens with due process and hearings. You may want to consider a parent or student orientation or signature sheet. A lot of our districts go over the code of conduct with our students. They, during the first 2 days of school, they'll review it and have students sign off that they received the code of conduct and they reviewed it. This just negates any argument down the road that students may raise saying that they weren't aware of the code of conduct, they didn't receive a copy. You're having them sign something. And this doesn't need to be pen and paper signature. We do have districts that also provide this online and have electronic signatures available for families. You obviously want to define the types of discipline as we've touched on. If your state uses a progressive discipline model, you want to explain how any behavior history will be considered during a hearing. You might also want to explain that progressive discipline model. That's something that parents especially get very confused about, thinking that students are entitled to the lowest level discipline consequence before you can move up to a higher level discipline consequence, which I'm sure most of you who deal with progressive discipline know is not true, and that's not what progressive discipline means at all. So it's a good idea to address that in your code of conduct and really spell out what progressive discipline means in your school community. And of course, you also want to highlight any code violations that have required discipline consequences, so people are put on notice of required amounts of discipline. For my college and university people who are on the line right now, some things to consider and keep in mind with your student handbooks and code of conduct. You want to obviously make the code accessible to students. You should consider any access issues for students with disabilities, physical disabilities, any mental disabilities. You may need to provide that code in various formats. You may also want to consider language problems with people speaking multiple languages, having it available in multiple language formats so that it is accessible to all students. Obviously, you want to define the types of discipline. You want to state whether a student's discipline history is going to be used during the hearing and how, and if so, how it will be used. Generally, this comes into the second part of the hearing after a student's been found in violation of a rule. You may consider their discipline history in determining the amount of discipline you want to assign or disciplinary consequences. However, your state may allow you to use that discipline history in other ways. So if you are going to use a student's discipline history, you should spell out how you're going to use it and all the purposes that it will be used for. Again, like the K-12 schools, you want to highlight code violations with required discipline. And you might want to discuss the extent to which a student's parents or guardians, attorneys, other people that they may want as a support system can be involved in the disciplinary process.
And of course, at the university and higher education level, we would need student consent to share any information with a parent or guardian or third party, and similar with K-12, before we would let an attorney or any third party see information that isn't a parent or guardian, we would want that consent as well. So of course we acknowledge that. in this thought. And because we are supposed to end at 1:30, we're not going to spend as much time on the notice. We'll have to go a little faster through the notice and the discovery, which I know Samantha's going to handle, so that we can kind of get to some of the high points of our hearings themselves. So, but again, we've made these slides really robust for you, so they're available for you.
Okay, so what is notice? Notice is when you put the student on notice of the rule that they are accused of violating, and whether there is going to be a hearing and any consequences. There's some court cases here that kind of give you some background as far as what must be included in notice. The key takeaway here is make sure it's timely. We're going to go a little bit more into the notice on the next slide. So our best practices for notice for the K-12 schools, you really want to put that notice in writing, hand deliver it or send it by U.S. mail to the parent guardian. You obviously want to list out the specific charges. The student should know what rules they're accused of violating. That just makes sense. You may want to include a brief statement of the incident that is the subject of your hearing. This puts the family on notice of why they're coming to a hearing, essentially. Obviously, the rules violated should be listed, date, time, place of hearing. That just makes sense for everybody. If you want somebody to come to a hearing, you need to tell them when it is and where to go. Any procedures you have regarding legal representation, whether or not the student can be represented by an attorney, and if so, whether you want notice of that representation ahead of time and how far in advance they need to notify you of that. Those are all good things to include. List of witnesses and evidence to be presented at the hearing. This does not need to be this huge comprehensive list. Names can be listed out, and you can just generally list out evidence that you plan to use. Testimony, documents, photographs, videos. You don't need to get too specific unless your state law requires that. And the penalty being sought by the school, including the maximum penalty allowed. So what you're seeking may not be the maximum penalty, but you should notify the student's family of the amount of discipline you're seeking to impose on them should you prevail at the hearing. Higher ed, a lot of this is very similar. Obviously, written notice, list the charges and rule and policy violated, notify them of the date, time, place of hearing, procedures regarding legal representation, list of witnesses and evidence to be presented at hearing, and the penalty. And it's also a good idea to include a copy of the Code of Conduct or handbook when you send this out, or copies of the actual rules printed out so people have those in writing. Discovery. For those of you who are not attorneys, discovery is the process by which we exchange information before a hearing. We tell the other side what information we have and we intend to present at hearings or trials. Under federal law, now your state might be different, but under federal law, there is no right to discovery in a student discipline hearing. So what this means is that if you don't provide discovery to the student ahead of time, it will not be a due process violation unless your state law says differently. So you don't need to turn over all of your documents and videos and evidence to the student ahead of the hearing for them to review. The downside, this is not one-sided. What that means is that you're also not going to get discovery from the student. So if your state law does not have a requirement for discovery and you are not providing the student any discovery, you're not going to get any discovery in return. So you're not going to know what evidence they want to present. Best practice, and what I usually encourage my clients to do, is to provide information if it's not going to violate other laws and is easily accessible. So I don't like to play hide the ball with discovery that I have easy access to and can easily send to the student or their attorney. If I have the information, I'll send it, as long as it's not going to put any student witness in danger or other witnesses in danger, and it's easy for me to send. The benefit to that, what I have found over time, is that when I send that information that I don't need to send, oftentimes the student or their attorney will let me know who they plan to call at the hearing or any documents that they intend to introduce at the hearing. What happens is that we tend to get discovery from the other side by being open to sharing with them. Again, not legally required, but it can be a good practice. K through 12 schools, you are required in your notice to provide a list of potential witnesses and evidence to the student. If possible, like I said earlier, provide copies of photographs, statements, or other documentary evidence in advance if it's easy and you don't feel like it's going to put anybody in danger. You do want to consider FERPA and any state privacy laws you have. So instead of listing out student witness names, you may want to use their initials or some other way to identify them. You may also need to redact any student statements, redaction of names or identifying information, especially if you're going to give copies of that to the family for them to keep ahead of time. So just keep that in mind. Higher education people, my college and university people, there is a court case down here, 1978 from the Supreme Court, that you all have less stringent procedural requirements in academic dismissal cases versus normal misconduct cases. However, it's still a good practice to provide that list of potential witnesses and evidence in advance of the hearing. Of course, you want to keep in mind safety issues and the availability of evidence ahead of time. But if you can turn it over, best practice is to turn it over. Exonerating evidence. This is going to be evidence that shows that the accused student did not violate the rule. So if you have evidence that shows that maybe a different person committed the rule violation, or this student was acting in self-defense or is potentially quote unquote innocent, you want to turn this over. Don't withhold that. There's really no reason to do that. If you have evidence that is exonerating a student, I would really question also why you would be proceeding with a discipline hearing against that student, but certainly you should provide them that evidence. Withholding evidence, like I have touched on, there may be occasions where you don't want to turn over all of your evidence. You want to weigh the danger of showing the accused student that evidence versus any potential due process concerns. So if you have a student who may be very scary, you're concerned about witnesses or a victim being intimidated by them if you turn over a lot of information ahead of time, that might be a situation where you may want to consider withholding evidence ahead of the hearing. But otherwise, if it's a very simple matter, maybe not. Okay, your hearings and tribunals. This is not a criminal trial. You want to set that expectation. However, there are some things that are similar to criminal trials. First of all, students must be presented an opportunity to present their own defense. This means that they are able to cross-examine your witnesses. If you call someone to testify, the other side gets to question them as well. It's not one-sided. They also get the opportunity to call their own witnesses during the hearing. They get to present any evidence that they want to present, and they get to state objections to your witnesses and your evidence. You also get to state objections to their witness and their evidence. There's a burden of proof. Suzann touched on this earlier. Different states may have different burdens, so keep that in mind during your hearing. You should have an impartial decision maker. That person, you should provide training to them in weighing evidence and credibility of witnesses to make a decision. Make sure your training is not biased, that it's somehow training them to find every student who's accused of something guilty, for example. So you want to keep that in mind when you develop your trainings. There are different types of decision makers you can use: hearing officers, hearing panels. I know some colleges and universities also use panels of students at times. So you want to consider different options for hearing officers or hearing panels, and also consider whether you are allowing your accused student to choose what form of hearing they want. I know, especially with some colleges and universities, you have several different options of types of hearing, and students can choose who they want to hear their case. So if you have that system, make sure it's spelled out in your handbook. K through 12 schools with hearings. So subpoenas, a lot of K-12 schools have the ability to issue subpoenas. However, you don't have subpoena power the same way a court does. You can't lock somebody up in jail because they didn't come to your discipline hearing, which may seem unfortunate to you. So just keep that in mind. I would be careful with your employees, however, especially if they are subpoenaed to a hearing and they indicate that they don't want to come. You may want to consider how you are going to address those issues with your own employees. I would encourage that you have policies in place that they know that they should be coming to discipline hearings if they are subpoenaed. Like we said, they have the right to cross-examine witnesses. You should have some sort of direct evidence of your rule violations that you are going to present. You shouldn't be just relying on gossip or hearsay in your discipline hearings. There should be some direct evidence of the rule violation. There is no right to state-provided legal counsel, so you don't get a public defender in your student disciplinary hearings unless your state law states otherwise. The student should, however, have a right to have a parent or legal guardian present for the entirety of the hearing. The hearing decision should be clear and should be written and should also be provided to the student and their family as soon after the hearing as possible. And also make sure that you are notifying the student of any appeal rights during the hearing. Higher education clients, similarly, you don't have that subpoena power like courts do. However, there has been some recent case law that suggests that students should have a right to confront their accusers. So this is going to be especially in cases where you have a victim. You may be able to put together a case to satisfy your burden of proof without having that victim testify. However, we want to be careful with that case law, and if students have the right to confront their accuser, you may need to bring in that victim to testify, even if they don't want to. The student or their attorney has a right to cross-examine witnesses. For sexual misconduct cases, I just want to highlight this for college and university. Any decision makers, that means your hearing officer or panel members, they must undergo specific training to deal with those types of hearings. So this is college and university folk. If you have hearing officers or hearing panels hearing sexual misconduct cases, you want to make sure that they have undergone the specific training required to do that. Like our K-12 people, you obviously want to provide them a written decision and the appeal rights also.
And I will just go ahead and let you all know that we are keeping a close eye out for the Title IX regs and the Title IX guidance. So we're keeping an eye on that Title IX world, and we'll be, as soon as those drop, we will be definitely hitting the webinar circuit pretty hard to explain to you what that means for due process and sexual misconduct issues. So we'll be sure to bring those to the forefront when they're available, and we'll keep you posted on that. And I'll just go ahead and finish this out here with private school processes. As we talked about at the beginning, this is a bit of a review for our private school folks. The school generally, you're going to have broad discretion to adopt procedures for your discipline and hearing processes. But again, this doesn't really alleviate you from the responsibility to let people know what your processes are going to be, because if you don't, you're buying yourself a lot of trouble with unhappy parents and students, because they will, number one, claim they didn't know and you weren't fair, but also that can be considered a contract and contractual breach. So, and also remind your students, your staff, remind everyone, look, if we say it, we mean it. We're not going to make arbitrary exceptions to our processes. And so we want to make sure that our processes, number one, are workable and are rooted in reality. But number two, that we're being consistent. And that's a note, I think a good final note for all of us on this call today, which is if you've got a process in place, you want to make sure that your folks know about it, they've been trained on it, they understand that we're being consistent. Because if you deviate from the great processes you develop in line with this conversation we've had today, and you treat students differently, you're really lining yourself up for bigger problems. So we want to make sure that we're giving due process consistently across the board. We are certainly thrilled you joined us today. We know that we took it right down to the wire. Samantha did a great job of giving you a lot of information in a short amount of time. And obviously, we've only begun to scratch the surface. So if there's something that we can help you with, we are happy to do that. Here is our contact information. These are our office lines. Obviously, like you all, we are working from home. We're checking that email. If you leave a message on our voicemail, it actually comes to us as an email. We're happy to call you back. So if there's anything we can do to make your life easier during this very, very stressful time, we are more than happy to do it. And again, I just want to say thank you. Samantha and I both come from families of educators, and we know how hard you're working, and we're right there with you working around the clock. So, you know, we're all in this together. It's going to be okay. We just have to get through it as a team, and we really appreciate you taking time out of your day today to spend time with us. And Samantha, if there's anything you want to say, I'll shut up for a second.
Oh, sorry, I had put you on mute. Nothing more from me. Just super happy to have you all with us today. And just echoing Suzann, if you have any questions, please feel free to reach out to us. We love working on these issues and helping you guys out with all of your questions and concerns.
Absolutely. And you all have a wonderful day.